agreement are being unilaterally redrawn by the claimants. The claimants are trying to force us into an agreement that the respondents did not agree to in the first place. Today, I, Ishika Jain, along with my co-counsel Anika Sehgal, appear on behalf of the respondents, LexCorp LLC. Over the course of the next 19 minutes, I shall be arguing the issue pertaining to the jurisdiction of the case, following which my co-counsel will then take up the issue pertaining to the merits of the case. Will the tribunal require a brief summary of facts?
Thank you. We have a summary of the facts.
Thank you, Madam Presiding Arbitrator. Moving ahead with my submissions, over the course of my submission, I shall be seeking to satisfy this tribunal that 1. The arbitral tribunal has been invalidly constituted, and 2. That the subject matter of the dispute falls outside the scope of the arbitration agreement. Proceeding ahead with my first submission, that the arbitral tribunal in the present case has been constituted invalid. Per Article 30, Subclause 1 of the Arbitration Act 1996, invalid constitution of the tribunal is a valid ground for challenging the jurisdiction of a tribunal. Herein, it is our submission that the appointment of the presiding arbitrator has been done in a faulty manner, and thus this tribunal does not hold the jurisdiction to govern the present dispute. To substantiate the same, I pointed out to the arbitral tribunal that in the present case, the parties have chosen WIPO Arbitration Rules 2021 to govern the arbitral proceedings. Now, I request the members of the tribunal to turn to page 6 of the Moot record. The said document is a coexistence agreement signed between the parties. I request the members of the tribunal to focus on clause 7.2 of the said page. If all the members of the tribunal are with me, page 6.
Yeah, proceed.
Thank you, Madam Presiding Arbitrator. Now, clause 7.2 clearly states that the arbitral tribunal shall consist of 3 arbitrators. There are 2 things noteworthy here. 1, that the parties have decided on the number of arbitrators, and 2, that the parties have not decided on a further procedure to be followed in the appointment of the arbitral tribunal. In such a case where the number of arbitrators has been decided and the procedure has not been determined by the parties, Article 17 applies. For the convenience of this tribunal, I shall substantiate the same using Article 17, Subclause 8. I shall read out the said article of the WIPO rules, Article 17, Subclause 8, which reads as, where 3 arbitrators are to be appointed and the parties have not agreed upon an appointment procedure, the arbitrators shall be appointed in accordance with this article. As already substantiated, that the number of arbitrators has been already decided to be 3 in the present case. However, considering that the procedure has not been determined, this article shall govern the appointment of the arbitral tribunal. Now, Article 17 provides for 2 ways in which the arbitral tribunal can be constituted. One of them being provided in Article 17, Subclause B, and the other being provided in Article 17, Subclause C. For the same, I request the members of the tribunal to turn to page 13 of the Moot prop. The said document is an email by the center, and I request the members of the tribunal to look at the top of the page, Constitution of Arbitral Tribunal. If all the members of the tribunal are with me?
Yes, thank you.
Thank you, Madam Presiding Arbitrator. I request the members of the tribunal to focus on last line of the said paragraph. It says Article 17, Subclause C. However, it is our submission that in the present case, Article 17, Subclause C could not have been applied by the center. This is because Article 17, Subclause C provides for a procedure when the number of arbitrators have not been decided by the parties. Thus, the center has falsely notified this procedure under Article 17, Subclause C, considering that we have already substantiated that the number of arbitrators has been decided by the parties. If the members of the tribunal follow me till here, our next submission is that in such a case, considering Article 17, Subclause C would not be applied, Article 17, Subclause B forms the relevant portion of the procedure which shall be applied in the present case. For the convenience of the tribunal, I shall read out the relevant part of Article 17, Subclause B, which the center had to follow in the present case. The last line reads as, that the 2 arbitrators shall within 20 days After the appointment of the second arbitrator, shall nominate a third arbitrator who shall be the presiding arbitrator. There are two things which we need to note here. The first one being that there has to be a time period of 20 days which has to be given to the co-arbitrators in order to choose a presiding arbitrator. Secondly, it is also important to note the phrase which has been used there is appointment. WIPO arbitration rules 2021 provide a distinction between nomination and appointment. The same has been provided in Article 14, subclause C of the same rules. For the benefit of the tribunal, I shall read out the relevant article. I quote that any nomination of an arbitrator made by the parties pursuant to Articles 16, 17, or 18 shall be confirmed by the center and provided that the requirements of 22 and 23 have been met. The appointment shall be effective upon the center's notification to the parties. Hence, it is our submission that the nomination becomes effective or is converted into an appointment only when it has been confirmed by the center. It is when this confirmation is done that the appointment is deemed to be effective. The same interpretation has also been provided by the WIPO official commentary to interpret the current clause. Now, I request the members of the tribunal to turn to page 22 of the Moot record. The said email is a center by the said document is an email by the center dated 20th of February. I request the members of the tribunal to focus on the bottom of the page where the appointments have been written. Herein, one can clearly see that the first two co-arbitrators have been confirmed by the censor by this very letter on this very date. However, even the appointment of the third arbitrator has been made on the very same date. Thus, the lapse of 20 days, which was required to be given to the co-arbitrators to choose their own arbitrator, has not been provided in the current case. Thus, the appointment of the presiding arbitrator has been done as opposed to the WIPO arbitration rules.
I have a question to you on a slightly different point. Sorry to interrupt your trend of thought on your question for arbitration, but if you look at your answer at page 17 of the brief, your basis for challenging jurisdiction in your answer is a little different, isn't it? It is on the basis that the coexistence agreement does not, I'm referring to paragraph 10, that your coexistence agreement does not explicitly provide for the resolution of disputes related to the refusal of trademark applications in specific jurisdictions. There is no mention in your answer of a challenge based on the appointment of the presiding arbitrator. How would you address that?
Yes, Mr. Arbitrator. To substantiate the same, there are three places from where we draw this right to challenge the procedure in which the arbitral tribunal has been constituted. The first being the very page that the learned Mr. Arbitrator has pointed out. The particular clause mentions on clause number 9 that the respondent has asserted a challenge to the jurisdiction. Further, in the challenge, it is written that the basis of the objection is primarily rooted in the fact. Thus, we are not barred from raising objections on other grounds. The primary ground could be this. But considering that the appointment of the arbitral tribunal and the way in which the tribunal has been constituted forms an important part of the arbitral proceedings, it is a valid ground to challenge jurisdiction. Further, I request the members of the tribunal to turn to Procedural Order 1, given on page 23 of the Moot record. 25 of the Moot record, my apologies. The said Procedural Order 1 is the order which governs the scope of the current arbitration proceeding which we are having. Herein, the point relating to jurisdiction has been mentioned in itself as a ground which will be discussed in the current case. No further reservations have been made as to on what grounds the current dispute will be challenged. Thus, we can raise objections on this ground. Further, I would also like to point the members of the tribunal to page 31 of the Moot problem that refers to the clarifications. Herein, I request the members of the tribunal to look at Article 30, question number 39. Question number 39 regards itself with the procedural inconsistency under Article 19, subclause B. In answer to this, it has been clarified that the parties can make all relevant submissions in regard to the jurisdiction of the current tribunal. Thus, we can make an objection to the jurisdiction of the current tribunal on grounds of invalid constitution of the arbitral tribunal.
following up on my co-arbitrator's question, you see your paragraph 10 of your defense is based on paragraph 9, which is jurisdiction, right? So jurisdiction, your basis of objection is, as my co-arbitrator stated, was on the substantive issue of whether the coexistence agreement, whether the clause will apply to the coexistence agreement. And the interim, the procedural order also says, simply says the jurisdiction of the arbitral tribunal to hear the dispute, right? So you mentioned that you have 3 supporting cases that you can raise a jurisdictional issue even if not strictly pleaded in your or raised in your preliminary documentation.
Mr. Arbitrator, even in the preliminary documentation, the reason which has been cited is preceded by the clause primarily. That means that it is the main objection of the parties, but there can be other objections which the parties can hold. Further, before this request for arbitration, the presiding arbitrator had not been appointed till that point of time. Thus, till here, we did not raise the objection in particular about the presiding arbitrator's appointment. Further, when the presiding arbitrator was finally appointed on 20th of February, in the very next opportunity that we got, which was the telephonic conversation, we have raised the given objection, because of which the ambit of procedural order 1 is wide, only stating that the jurisdiction of the tribunal is in question. We reserve the right to challenge the jurisdiction of the tribunal on the procedural grounds thus.
So what you say in a sense is that you did not have the opportunity to raise that as at the 25th of January when you filed your answer.
Yes, Mr. Arbitrator, because till that time the presiding arbitrator had not been appointed yet.
So the arbitrators, the clause requires mandates that it's within 20 days, isn't it?
Yes, Madam Arbitrator.
So it has been very promptly done, and the person has been appointed, the third arbitrator has been appointed on the 20th, correct?
Yes, Madam Arbitrator.
So isn't that within 20 days? Because the problem, as I see it at the moment, is this merely an administrative irregularity at its very best, or is there something about some prejudice caused to you in this because of this appointment, or is it just something which you are just bringing up and as an argument by the way?
Madam Arbitrator, the first objection regarding it falling within the 20 days time period is not true. We beg to differ because Article 17 subclause B provides for 20 days from the appointment of the arbitrators. As already substantiated, that the appointment is only when it has been confirmed by the center. The confirmation here has only been done on 20th of February, and on the very same date, the third presiding arbitrator has been appointed. Thus, the 20 days time period has not been followed. Further, to answer the second question of Madam Presiding Arbitrator, that is this merely an administrative inconvenience? The Council begs to differ. The very ground on which arbitration proceedings are based is party autonomy. Having to choose their arbitrators and the process by which the parties can appoint their arbitrators forms a core of such arbitral proceedings. Further, Article 30, subclause 1 of the Arbitration Act provides that irregular constitution of the arbitral tribunal is a valid ground to challenge the jurisdiction of the tribunal and is not merely an administrative inconvenience. Further, Article 1, subclause B of the Arbitration Act talks about party autonomy to be given precedence in arbitral proceedings. Further, to substantiate the argument, we cite the case law of Silver Dry Bulk Company, where it was clearly held that if there are procedural inconsistencies in the appointment or the constitution of the arbitral tribunal, that means there is a valid ground and a well-reasoned ground to substantiate the jurisdiction of the arbitral tribunal.
Do we have a copy of that decision that you're citing at the moment?
Madam Arbitrator, the Arbitration Act has been provided in the compendium, and the Silver Dry case has also been there in the compendium.
Is it ultimately your position that the appointment of the president of the chairman of the panel has been done without the concurrence of your nominated arbitrator?
Yes, Mr. Arbitrator, that is precisely our submission.
Going back to that,
Yes.
are you saying that your arbitrator nominated by you acting in terms of 17C did not concur in the appointment of the chairperson?
So,
Or is it just that they didn't do it within 20 days? So you're giving expanded version of within 20 days. As the chairperson said, 20 days can be 1 day if it is within. Right? So what we are asking is whether it is your contention that that you all didn't that your arbitrator did not nominate a third party. Is that your part of it, or is it only that the time limitation?
yes, Mr. Arbitrator, before I answer that question, considering that I am exceeding my time, I request an extension of 3 minutes from the arbitral tribunal to sum up this question and my further arguments.
Of course.
Granted, of course.
Thank you so much, Madam Presiding Arbitrator. To answer the questions sir raised, sir, our contention here is both. First of all, the parties have not, the co-arbitrators appointed by us have not been given an opportunity to provide, have not been given an opportunity to appoint the presiding arbitrator. This is because, as one can see, that the presiding arbitrators and the co-arbitrators have been appointed not only on the same date, but much less the same letter. Thus, the co-arbitrators were not even given an opportunity to appoint the third or the presiding arbitrator. Thus, the center has blatantly violated party autonomy in the present case.
Yeah, we've taken your point, but you have got your instructions on that your arbitrator did not have time to concur with the arbitrator who was suggested the name of the third arbitrator.
Yes, Madam Arbitrator, our co-arbitrators were not given the opportunity to appoint to nominate the presiding arbitrator. If my first submission is clear with the members of the arbitral tribunal, I'll move ahead to my second submission that the current dispute is not covered within the scope of the arbitration agreement. Though the first submission by us in itself is enough to take away the jurisdiction of this tribunal, this is our second independent submission, which in itself will also take away the jurisdiction of this tribunal to hear the current dispute. To sum it up, because of the brevity of time, we submit that the current dispute does not fall within the subject, the current subject matter does not fall within the ambit of the arbitration clause. The arbitration clause given under 7.1 of the WIPO arbitration clause, I have the members with me, it is on page number 6, 7.1 clause. The arbitration clause reads that the parties hereby agree that any dispute arising out of or in relation to this contract shall be referred to and finally determined by arbitration in accordance with the WIPO arbitration rules. From a plain language reading of the clause, and if the words of the clause are given their ordinary and natural meaning, which is the first step in interpretation of clauses per the Arnold versus Britain case, the ordinary and natural meaning of the current clause restricts the tribunal's jurisdiction to only disputes which arise directly out of or in relation to this contract. Considering the fact that refusal of trademarks in specific jurisdictions is not related to the coexistence agreement because the agreement only talks about non-interference and mutual coexistence.
You're not having the attention. He was doing something urgent, so you must pause. Can you just repeat that? We'll give you the extra minute. Okay.
Thank you so much, Madam Arbitrator. I shall repeat that to begin with, to interpret the arbitration clause, we will have to look at the natural and ordinary meaning of the words. Here, the words used are any dispute arising out of or in relation to the contract. Per their ordinary meaning, given the fact that the current dispute, which is refusal of trademarks in specific jurisdictions, is in no way related to the contract because the terms of the contract talk only about coexistence and non-interference, this does not directly arise out of or in relation to the contract. Even the preambulatory clause of the coexistence agreement, which talks about facilitation, has a limitation that it has to be read in light of the clauses. This has been held in the Attorney General versus Riverdale case. Considering that the clauses only talk about non-interference and mutual coexistence, the current dispute cannot be related to the arbitration clause. Further, it is our submission that even the intention of the parties posits the same, that they do not wish to include this subject matter within the purview of arbitration. This can be deemed from 1, the facts and circumstances known and assumed by the parties and commercial wisdom, and secondly, the model WIPO clause. I shall go ahead with my first prong first, that the facts and circumstances known by the parties and commercial wisdom dictates that the parties did not intend the current dispute to be included within the ambit of the arbitration agreement. This is because both the parties, being seasoned players in the markets, involved in litigation of registration of trademarks for years on end, know that refusal of trademarks is an intrinsic process of the trademark registration process. Despite this, the fact that the parties have not yet included an explicit obligation to include the current dispute within the contract's ambit shows that they do not intend the current dispute to
Council, your time has elapsed.
Your sentence, yes.
Madam
Finish your
Arbitrator,
sentence.
yes, Madam Arbitrator, can I just take 20 seconds to sum up my argument and conclude my submission?
Yes, do we have 20 seconds? Can we give her that 20 seconds, Mr. Timekeeper?
Closing of the 3 minutes already granted.
Yes, Mr. Arbitrator.
Thank you, Madam Presiding Arbitrator. To sum up my submission, considering the fact that the arbitral tribunal, especially the presiding arbitrator, has been invalidly appointed, considering that Article 17 subclause C was a faulty procedure, further Article 17 subclause B has not been followed, and Article 19 subclause B, there is no record of it being ever followed. It is our first submission that the tribunal lacks jurisdiction because of that. Secondly, considering that the ordinary meaning and the language of the words used in the arbitration clause, the intention of the parties, the facts and circumstances known and assumed by the parties in itself submit that the parties did not intend the current dispute to fall within the jurisdiction of this arbitral tribunal. If there are no further questions, that concludes my submissions for the jurisdiction arm.
I do have a question which perhaps can be addressed by the other counsel when they address it. I believe, to my mind, the matter in dispute is not really the question of the refusal of the registration of the mark by the authorities, but rather a violation in particular in the coexistence agreement of clause 1.2, which is a refusal to have a licensing agreement and an implied clause which suggests, or an implied term which suggests that there would be cooperation given clauses 1.1 and 1.2. That was my reading of the coexistence agreement and the statement of claim. If you would address that when you deal with it.
Yes, Mr. Arbitrator. The questions which have been asked relate to merits, and my co-counsel will address them while addressing the issue. However, the scope of the jurisdiction, as itself highlighted by the claimants, in itself is whether the particular dispute is related to the arbitration clause or not. Whether the dispute arises out of, or the obligation arises, or the license agreement has been reached, will be dealt with my co-counsel in merits. However, whether it relates to the arbitral clause or not has been dealt with by me in the present jurisdiction.
Right, thank you. We'll have the next speaker now. Thanks.
It has been an honor arguing before this tribunal.
Good afternoon, members of the tribunal. I'm Shermaine Au, and together with my co-counsel, Mr. Quek, we appear for the claimant Wayne Enterprises. I will be using 90 minutes for my submissions and 1 minute for my rebuttal. Contrary to the respondent's position, we submit that the case at hand today concerns the fact that the claimant's rightful opportunities for growth and prosperity have been unjustly stifled by the respondent's actions. The claimant has been very hopeful that the coexistence agreement will see an end to the legal battles that both parties were previously embroiled in. However, we currently witness the respondent's disregard for the fundamental terms and intentions in this coexistence agreement. The tribunal here will have jurisdiction to hear the current dispute under clause 7.1 of this coexistence agreement. My co-counsel, Mr. Quek, will then demonstrate why the respondent has breached this coexistence agreement, in particular, clause 2 of this coexistence agreement, by refusing to assist us in our trademark registration application, as well as by refusing to agree to the claimant's proposal for a license agreement. I will now be demonstrating why the respondent's case will fail on the following grounds. With this, I turn to my first submission. In response to the opposing counsel's submission earlier, the appointment of the preceding arbitral tribunal is invalid. We disagree here. First, we would like to highlight that there's nothing in the record that shows that there's any evidence that shows such irregularity of the procedure when appointing the presiding arbitrator. Moreover, we cannot rely on such speculative claims as submitted earlier by our opposing counsel. And due to such speculation, we submit here that the respondent opposing counsel here has not passed the burden of proof to show that their case here will pass. And as relying on the 2021 UK Court of Appeal case of TUI UK Limited, it states that such principle that the respondent here, the opposing counsel, should bear such burden of proof is tried law. And then relying on such speculative facts which is not found in the record here would certainly fail. Moreover, I note earlier that Mr. Arbitrator on the right of presiding arbitrator has raised a concern earlier that the pleadings submitted by the opposing counsel here is regarding the breach of the coexistence agreement regarding our trademark registration application as well as the license agreements, which can be found on page 17 of the record at paragraph 10. Members of the tribunal, if I may quote, the pleadings relied on by the opposing counsels here and the respondent is relating to the refusal of trademark applications in specific jurisdiction, and this, we submit, is the subject matter of the current dispute here, and relating to the procedure of the appointment of the presiding tribunal. This, we submit here, should not be a contentious issue here, especially since we have nothing on the record that shows this, that proves this, and it's too speculative for the opposing counsel to bring up such claims.
Is it your position that the argument that there has not been concurrence of the appointment of the presiding arbitrator cannot be raised at all, or is it that that is not the primary basis on which they are relying? Because we heard from the respondents' counsel that their pleadings were limited to a primary basis, and they did not cover all the bases on which they were hoping to challenge jurisdiction. What is your view on that?
Yes, regarding this, we are submitting that, of course, certainly the opposing counsel can bring up such claims. However, we submit that there is insufficient evidence for the opposing counsel to prove such claims here, and we need to highlight and emphasize that the current dispute and subject matter at hand would be relating to the breach of the coexistence agreement, in particularly clause 2 as well as clause 1.3 of this coexistence agreement, relating to registration, the trademark registration application, as well as the license agreements respectively.
Okay, just to go, sorry, sir.
No.
Just to go back to the earlier question, so do you concede that all preliminary or all objections to jurisdiction need not be pleaded, and that there is room to raise preliminary objections on jurisdiction even at the hearing subsequently? Do you concede that? Because then we can...
We submit that we do not concede to this. However, we would like to highlight that because the opposing counsel here is relying on insufficient evidence to prove their case here, this cannot be upheld. And certainly this has not also been pleaded in their pleadings.
You did hear the fact that they said that they could not be pleaded because the answer was in fact filed prior. So in that context, your defense that it was not pleaded may not hold water. Isn't that the case? What do you feel?
Yes, Mr. Arbitrator. Even if our case at hand does not hold water regarding the pleadings, we submit here that the opposing counsel cannot use such speculative evidence to bring up their claims regarding the appointment of presiding arbitrator, because the burden of proof lies on them, and we submit here that such burden of proof will not have been passed, and they will not have passed the balance of probabilities test. Next, I would like to respond to the scope of the arbitration of the coexistence agreements here. And members of the tribunal, I would like to refer you to page 6 of the record at clause 7.1. If I may quote at clause 7.1, the parties hereby agree that any dispute arising out of and or in relation to this contract shall be referred to and finally determined by arbitration in accordance with the WIPO arbitration rules. Here, the opposing counsel seeks to argue that the current dispute at hand falls outside the scope of clause 7.1, for which we disagree. Here, there are two disputes at hand. First, it will be a dispute relating to the registration of the trademark registration application, as well as relating the claimant's proposal in relation to a license agreement in the specified Asian jurisdictions. Here, it has to be highlighted that the word dispute should be given a broad meaning, and this can be found in the 2004 UK High Court case of Amex Civil Engineering. Since the two disputes at hand we submit here would certainly be reasonably foreseeable to fall within clause 7.1. And here, we will rely on the 2012 UK High Court case of Lombard North Central, where the court held that in determining whether a dispute is reasonably foreseeable, this depends on the nature of the claim made and whether such questions would foreseeably arise for determination in the proceedings. It can be seen that given the fact that first, if the respondent deems such registration to be a threat to their trademarks, they would necessarily set up resistance. And second, parties also did envisage the proposal of a license agreement given that there's a caveat that if each side refuses, such refusal needs to be reasonable and in good faith, as set out in clause 1.3 of this coexistence agreement. Hence, we submit here that both of these disputes would be reasonably foreseeable to fall within the scope of clause 7.1. Moreover, we would like to highlight the 2007 UK House of Lords case of Fiona Trust, where the court held that the construction of an arbitration clause should start from the assumption that parties, as rational businessmen, would likely to have intended such disputes to fall within clause 7.1 of this arbitration clause in this coexistence agreement. Here, we submit that parties, both the respondent and claimants, as rational businessmen, would certainly have intended for such disputes relating to intellectual property rights regarding registration as well as license agreements to fall within and have intended that such disputes would be arbitrated under clause 7.1. Furthermore, it has to be highlighted that the court held that unless there was an express language that excludes the specific disputes to be arbitrated, such other disputes would then be arbitrable. And hence, since clause 7.1 clearly does not explicitly state any of the disputes that we are currently pleading here regarding the registration as well as the license agreements, it cannot be said that the two disputes here would fall outside the scope of clause 7.1.
Are you citing any cases in response that the dispute is outside the jurisdiction of the court? Do you have any cases that you wish to, about the wide interpretation of jurisdiction? Do you have any cases to quote before the tribunal?
Yes.
Yeah. What are the cases?
Members of the tribunal, if I may highlight the phrase arising out of and or in relation that is stated here in clause 7.1 of this coexistence agreement, we would like to cite the case of the 2023 UK Court of Appeal case of National Iranian Oil Company, where the court held that the words of the coexistence agreement should be given paramount importance too. And the court there held that phrases arising out of and or in relation should be interpreted as one that gives rise to a broad meaning of the arbitration clause. And moreover, we would like to highlight that as parties, both the respondent and claimant have deliberately used such all-encompassing phrases arising out of and or in relation, it must be noted that this scope of the current clause 7.1 should be specifically wide such that a broad class of claims would be able to be arbitrated under clause 7.1 of this coexistence agreement to be decided by the arbitral tribunal today.
In fact, there is a 2007 and a 2021 cases where the concept was that it was a presumption in favor of a one-stop adjudication and that these limitations would be considered likely by the tribunal unless it was grounded in some serious prejudice, correct?
Yes.
Yeah. The other one, Milford Capital Partners. Yeah, you'll probably look at it later on. Right. Anything else?
Yes, thank you, presiding arbitrator. Secondly, I would like to highlight that in response to the opposing counsel's claim earlier that currently there's no explicit explicit statement in clause 2.1 that states that respondents should actively assist us in our trademark registration application for disagree. And we submit here that there is an implied duty on the respondent's part to assist us in our trademark registration application. And this, we rely on a purposive interpretation of clause 2.1 of this coexistence agreement. Here, we'll rely on the preamble, which can be found on page 5 of the record. At paragraph 5, if I may quote, whereas to facilitate the use and registration of their respective marks worldwide, the parties desire to enter into this coexistence agreement.
You're referring to the last recital.
Second last recital.
Yes.
Yes. With this, we highlight that the use of the preamble must be emphasized here, and hence a purposive interpretation of clause 2.1 must be needed. Hence, the disputes relating to the trademark registration application is still within the scope of clause 7.1. And regarding the merits of this case, my co-counsel, Mr. Quek, will then be demonstrating this further.
Thank you. She's within her time.
Yes, Madam Arbitrator.
Are those your submissions?
Yes, Mr. Arbitrator, if I may, unless I may be of further assistance to the tribunal.
Those are your submissions.
Yes, regarding the scope of clause 7 of this coexistence agreement, we submit here that the two disputes at hand would fall within the arbitration clause to be arbitrated by this tribunal. Furthermore, we would like to highlight that we noted that the counsel for the respondents here have cited in their memorandum written submissions that the tribunal cannot arbitrate such claims due to rights currently is in rem. However, we would like to highlight that the rights is in personam because the coexistence agreement is between two parties here, the claimant and respondent. Hence, whatever actions that the respondents do, it will directly affect the claimant's rights here. And furthermore, we would like to highlight that the UK law here should be given precedent to, and hence there would not be any public policy concerns because the UK law would still be applicable even for trademark registration applications to Macovia and Kasnia.
Madam Counsel, you primarily dealt with this question of jurisdiction. There was an argument raised by counsel for the respondent on the basis of the dates relating to the appointment of the two arbitrators and the chairman of the panel. You have not addressed us on that issue. Is that a matter that we are to assume that you do not contest that particular aspect of the claimants, of the respondent's submission?
And also, like, she made a very serious allegation that there was no party autonomy because the arbitrator for the respondent was not even consulted in the appointment of the third arbitrator.
So,
what do you have to say?
Yes, you have not addressed us on it. Are we to assume that you have conceded those positions?
No, we have not conceded. In response to the...
Is it your position that those assertions of the respondent's counsel is not supported by the facts?
Yes.
Facts of the case?
We are saying that there is currently no evidence and the opposing counsel here cannot rely on such speculative evidence here. And in relation to the first question earlier regarding the time period of 20 days, we agree with Madam Presiding Arbitrator here that there is no prejudice and it will be a...
Counsel, your time has elapsed.
And
You may continue 2 more minutes.
Thank you, members of the tribunal.
With your permission.
You may conclude your sentence. I didn't hear the last part of your sentence. If you may conclude that.
Yes. Regarding the time period of 20 days that the opposing counsel has cited earlier, we agree with the Madam Presiding Arbitrator's concern earlier that here there's currently no prejudice and at best it will only be an administrative matter here. And since there is no evidence here, the opposing counsel cannot rely on such speculative claims to argue that the appointment of the presiding arbitral tribunal has not been complied with. Thank you. Unless I may be of further assistance to the tribunal, this concludes my submissions.
Thank you.
Yes, could we have the next person?
The claimant, the respondent rebuttal can go on.
To begin with, with my rebuttals, we would first like to highlight that the learned opposing counsel has made no submissions which could hinder the argument which has been raised by the respondents regarding the procedural inconsistencies. The 20 days time period, it is not logically possible that considering the fact that it was in the very same letter that the confirmation was made, that the appointment of the third arbitrator was made. Further, these are not mere speculative submissions, and full evidence have been provided using the documents which the center has itself provided. Thus, it is not speculative at all, but backed by proper documentation. Further, it is not a minor administrative inconvenience because the confirmation by the center is made after all the important things such as impartiality, independence, availability, acceptance, and other major procedures. Only after this is done that the confirmation is done. The presiding arbitrator has to be appointed by the co-arbitrators which have been appointed by the parties. That in itself is the very highlight of party autonomy. So if the presiding arbitrator in itself is not appointed as per the procedure agreed on by the parties in the WIPO rules
Counsel, your
itself,
time is elapsing.
that in itself is a submission. Further, the Fiona Trust case, which the parties have highlighted, that in itself says that the broad distinction which they talked about regarding the out of or in relation and considering both are used, it's a broad clause. The Fiona Trust itself says that this literal interpretation has to be left behind and it has to be done in accordance with the intention of the parties. Thus, both the arguments of the learned opposing counsel fail.
May I just raise this question to you, and I can give you an extra minute to answer that.
Yes, Mr. Arbitrator.
That is, if with the permission of the chair.
It's on the dates, right?
Yes, on the dates. You drew our attention to page 22 of the brief, and you said that on the 20th of February, the confirmation of Dr. Henry Allen, Dr. Ray Palmer, and Professor Jonathan Crane were made on the same day. But if you were to refer to pages 14 and 15 of your brief, the appointments of the two arbitrators were in fact concluded by the 25th of January. So there was a time frame from the 25th of January, the appointments, up to the 20th of February, which is in a sense almost the 20 days is up there. During which time it has taken the center to confirm. So what is the evidence that you can give us to even suggest that there was no concurrence in the appointment of the president?
Because you made a very serious allegation that the arbitrator, in fact, what you said was that the only one party appointed the arbitrator. There was no concurrence, and therefore it's a matter of party autonomy. But there was nothing that you have till you made your submissions and your submissions to this tribunal. You have not sent any letter contesting it. There was no documentary evidence which was contemporaneous to this matter coming to your attention. Miss, are you listening?
Yes, Madam Arbitrator. To answer your questions one by one. First, to answer
Just
the
one
questions.
one more. Yeah, you want to.
No, my brother also refers to page 21 of the brief, by which point notice had been given to your counsel, to the other side as well, of the appointment of your nominee. And so from the 30th of January to the 20th of February, it was the 20-day time period during which we would presume that they conferred on this appointment. That's why I asked whether you had anything additional to show us that there was no concurrence.
Mr. Arbitrator, to address all those concerns, I'll go one by one in the order the questions have been asked. First of all, the two pages cited by the learned Mr. Arbitrator on page 14 and 15 regarding the arbitrators. It is a submission that on both the pages what has been talked about is the nomination of the arbitrators and not the appointment of the arbitrators. Thus, the dates, the 20 days will not be counted from this particular time period. Further, it is a submission to address the further concern of Mr. Arbitrator that the 20 days cannot be counted from this particular time period. It is only after the appointment that it has been counted. Further, it is not our submission that the confirmation has not been done by the center. It is our submission that the confirmation has been done on 20th of February and the time period of 20 days has to proceed after this confirmation. That answers the first two questions raised by Mr. Arbitrator. Then the second question, or the third question, which was raised by Madam Presiding Arbitrator regarding. Yes,
Sorry,
Mr. Arbitrator.
I just am compelled to ask you this. If you look at Article 17C in the appointment of arbitrators in the WIPO rules, it says clearly that there shall be a nomination of an arbitrator by the claimant. Then it goes on to say in the fifth line, the respondent shall nominate an arbitrator within 30 days after the receipt of it by the notification. And then it says the two arbitrators shall within 20 days after the appointment of the second arbitrator nominate a third arbitrator. So is it your position that the appointment can only be considered by a confirmation by the center and it is not the nomination that is really referred to there?
Mr. Arbitrator, there are two parts of the answer to this question. The first being that Article 17, subclause C, which has been referred by Mr. Arbitrator, begins with a proviso, which says that notwithstanding paragraph B, where 3 arbitrators are to be appointed as a result of the exercise of center's discretion under Article 14, subclause B. Now, Article 14, subclause B of the WIPO rules talks about a situation where the number of arbitrators has not been decided by the parties. Here, the number of arbitrators has already, continuing with my point, that Article 17, subclause C begins with this proviso that it is for situations where the discretion has been exercised under Article 14, subclause B. Article 14, subclause B in itself talks about a situation where the number of arbitrators have not been decided by the party. Considering that here the number of arbitrators per 7.2 of the coexistence agreement highlighted in the beginning of my submission says that the number of arbitrators is 3, the current submission, the current article will not apply here. Further, the second submission regarding the 20 days, it is precisely our submission that as Mr. Arbitrator correctly laid down, that the nomination and appointment of arbitrators is different. The 20 days time period as per Article 17, subclause B has to be after the appointment of the arbitrators. The appointment of arbitrators is only done when it has been confirmed by the parties and further effective when it has been notified to the parties. This has only been notified to the parties on 20th of February in the document highlight. Moving ahead with the second question that Madam Presiding Arbitrator asked regarding it hampering party autonomy and it being a very serious allegation. This is precisely our point, that if the procedure which the parties had agreed to has not in itself been followed, and that too in the appointment of the presiding arbitrator, it is a blatant violation of the not only the WIPO arbitration rules, but the very essence of an arbitral proceeding where the party autonomy has to be given precedent. Here, the procedure which the parties agreed to has been taken away from the parties by the center on its own discretion, which is something that it cannot do. Cannot do. The same has been also highlighted by the very essence of the Arbitration Act, in which Article 1, Section 1, subclause B clearly says that party autonomy is the main precedence of arbitral proceedings. Further, to answer the claim, further to answer the question which Mr. Arbitrator raised regarding Article 19, subclause B on page 21.
Before you get on to that, I have a question.
Yes,
Now,
ma'am.
you say you received the letter dated 20th February 2024.
Yes, Madam Arbitrator.
That was a very serious breach of your party autonomy if you had not got notice of the appointment and the confirmation of the third arbitrator. What did you do at that time? You got this letter? You got this letter, right? What did you do at that point?
Madam Arbitrator, the letter which we have gotten is on 20th of February, and that is the precise point where the violation has happened and our rights have been breached. In furthering this, which the respondents have raised a claim against the jurisdiction of this tribunal in the very next opportunity they got, which is in the telephonic conversation held on 29th of February, following which the procedural order 1 was made, wherein the jurisdiction of this tribunal is in question. To substantiate the same, I highlight a case law of Hayat versus Radisson Hotels, which is also given in the compendium, which we have submitted, where the issue was regarding this prompt objection or no. Herein, the court held that a delay of 23 days was held to be an unprompt objection. Here, we have made an objection in less than half of that particular time, which is in 9 days. Thus, the objection has been raised by the parties as a reply to the particular procedural breach.
But you didn't send anything in writing prior to that procedure order number 1, did you? Did you say that you were silent after getting the letter dated 20th February 2024? In the interim period, you were silent, right? There's nothing in writing whereby you have immediately said, I refuse the jurisdiction because I had nothing. I strongly object to the appointment of this third arbitrator. And this would be a preliminary matter that you would have to dispose before any sitting, prior to the sitting, where the direction order number 1 was made, even if it was orally. And you don't have a transcript of what happened in that conversation, do you? Are you nodding your head? Yes, yeah, no, you're saying no, right, okay.
Madam Arbitrator, to answer your question, firstly, the facts, the moot record is silent on the transcript of the telephonic conversation. Secondly, it is our submission that per the WIPO rules, Article 16, the objection raised, there is no condition for that the objection should be raised in writing or in any particular words. WIPO rules only say that any objection to the procedure in which the arbitral tribunal has been constituted has to be prompt in its response. Herein, it is our submission that we were prompt in response, considering the fact that the argument was raised by us in the very first opportunity where the parties next met and within 9 days of the constitution of the breach by the center.
Members of the tribunal, if I may begin. Regarding the opposing counsel's claim earlier regarding the appointment of the presiding arbitrator, for this here, we would like to highlight that the opposing counsel's submissions earlier, that rebuttal earlier, there were a lot of assumptions made, and the fact that the opposing counsel were using ifs in her submissions highlight the fact that there was no conclusive evidence here. And such serious allegations certainly cannot be upheld by this tribunal, and it could be construed and said that this could be a mere afterthought on the respondent's side. Therefore, we submit here that there is still jurisdiction to hear this current dispute, and such serious allegation cannot be upheld here as they are relying on no conclusive evidence and merely on speculative facts. Unless I may be of further assistance to the tribunal, this concludes my rebuttal.
I have a question on that. The argument was raised that the nomination of the arbitrator is different from the appointment, and that the appointment comes only on the confirmation of that appointment by the letter of 20th February. You haven't addressed that issue. Is it that you concede with that position?
Regarding this, we do not concede. We would like to say that this rightful issue here would be immaterial to whether there is jurisdiction to hear this current dispute here in the first place.
Thank you.
Thank you, members of the tribunal. This concludes my rebuttal.
So what are your views on this letter of at page 21? Yeah, you say the information, or there is an assumption by the respondent's counsel, but isn't there sufficient evidence in this brief itself to say that timings are correct? Look at 21. What are your views on page 21?
Mr. Arbitrator, here we submit that what was said on page 21 and what the opposing counsel has been relying on is merely speculative claims, as nothing in the record clearly shows there is any dispute here regarding the appointment of the presiding arbitrator. And furthermore, this letter here on page 21 also cannot be conclusive. Hence, we submit here that such serious allegations made by the opposing counsel cannot be upheld with no conclusive evidence being brought forward.
There's one point where she said that there was no confirmation. At least by the 30th of January 2024, there was confirmation and appointment both, isn't it?
Yes.
Look at the document and see.
Yes, we agree that there is confirmation regarding the appointment of the presiding arbitrator.
Members of the tribunal, if everything is in order, we can move on to claimant merits.
Much obliged. Members of the tribunal, are we ready?
Yes.
Yes, thank you.
Thank you very much, members. And a very good afternoon to the members of the tribunal, as well as my fellow learned friends. As introduced by my co-counsel, my name is Marcus Quack, and appearing for the claimant Wayne Enterprises, I will be speaking for a total of 20 minutes in today's submissions. Now, in the first 19 minutes, it will be the substantive part of my submissions, and I respectfully leave 1 minute for rebuttal. In the main part of my submissions today, I will be contending two issues. Number one, that there is a breach of the coexistence agreement by virtue of the respondent in failing to assist my client with their trademark applications. Number two, that there is yet another breach of this coexistence agreement because the respondent has refused to enter the license agreement per my client's request. Now, as it was put forward by my co-counsel, and I shall reiterate our collective sentiment on this, my client has been deprived of its business opportunities thus far. It is most unfortunate that the silver bullet to the parties' conflict, that being the coexistence agreement, has missed its mark, and they once again find themselves plunged into yet another bout of legal proceedings. Now, my client's initial optimism had been dashed by the respondent's conduct. And in today's submissions, I will demonstrate why their case cannot hold water. Now, in the first part of my submissions, members of the tribunal, I will be contending that there is a breach because the respondent has not accorded with its positive obligations when it came to assisting my client with their trademark applications. And I note that Mr. Sundere earlier also mentioned about the possible existence of such an implied obligation, and I will move to elaborate as to why this is present in the particular coexistence agreement. Now, for some context, members of the tribunal, I shall briefly explain the trademark registration process, as this is pertinent to why there should be an implied obligation here on the respondent. Now, when my client first made this trademark application to the trademark registry, the trademark registry will necessarily grapple with the existing trademarks within the jurisdiction and then form a determination as to whether or not there could be potential confusion that is caused with the current registrants of their trademark, as well as the trademark which is sought to be registered. Now, it is only at the stage where the registration has passed and been accepted by the registry that the trademark registration would be up for opposition. Now, we contend that this is where Clause 2.1 comes into effect, given its wording not to oppose or challenge the trademark applications as seen at page 5 of the record. Clause 2.1 is the last paragraph on page 5. Thank you, members. Now, as we can see from the wording here, it closely resembles Section 38 of the 38 subsection 2 in particular of the UK Trademarks Act 1994, where it sets out the formal opposition stage, which is part of the trademark registration process. Now, with this backdrop in mind, we are submitting that there ought to be an implied obligation here because there is clearly a gap as to the rights and obligations of the parties at the trademark application stage. Clearly, per the coexistence agreement, the parties have agreed as to the rights and obligations when it comes to not interfering the trademark registrations once it has been accepted by the registry. But it seems that they have not. Yes, Mr. Arbitrator.
No, finish your sentence, sorry. Finish your sentence. I'll ask the question after.
Certainly, Mr. Arbitrator. So it is our position that because that an implied term giving rise to this positive obligation would only be consistent with this pre-existing clause 2.1 in this coexistence agreement. Yes,
Okay.
Mr. Arbitrator, happy to answer.
Okay, thank you. So your point is that the assistance part is not specifically provided in the 2.1 and that you must imply that looking at the entirety of the coexistence agreement, that assistance becomes a implied term of the contract. Is that is the position, correct?
That is the position,
Right.
correct.
Okay.
To follow up on that, in the pre-arbitration questions, the assistance that you seek is in the form of a letter from the respondent confirming that they have no objections to the registration of your mark. Is that correct?
That is correct, Mr. Arbitrator.
What was to prevent you from tendering a copy of this agreement to the registry, which sets out those aspects already? And if, as you say, there was an implied provision, you could have made submissions on that to the registry itself. Why is it that you even require their assistance? Surely, being commercial organizations, the two of you entering into this agreement with a history of litigation, would have developed this agreement in order to prevent any further contest in these matters. How would you address that?
Certainly, Mr. Arbitrator. Well, the reason is because we need such an express consent from the respondent to be tendered themselves to the IP office, for which the claimant so seeks its registrations within. Now, as part of the UK Trademarks Guide published in 2019, members of the tribunal, it has also been noted that as part of the registration process, the Trademarks Office will contact registrants of trademarks who resemble the trademark that is sought to be applied, that is sought to be registered. My apologies, I misspoke. And
yeah, but the claimants, the the claimant's mark is not registered in that particular territory.
That is correct, Mr. Arbitrator.
Okay, so there was no obligation on the trademark office to then ask the claimant, correct?
Correct. My apologies, Mr. Arbitrator, if I was unclear, but the obligation lies on the respondent. So the trademark registry should have contacted the respondents to obtain their consent given the similarity of the trademarks.
Was there a previous registration by the respondent which needed the permission of the respondent before you registered? Was there something like
Yes, Madam Presiding Arbitrator, there is a registration by the respondents in Markovia and Kasnia, which is the Asian countries which the claimant is now trying to get their registrations in. However, there is no such express clause within the coexistence whatsoever that mandates the attainment of a permission from the respondent before my client can even attempt to apply for registration of their trademarks.
Continue with the present.
Much obliged, members of the tribunal. Now, as a second point to bolster my submission here, members of the tribunal, we are submitting that we have to look at the overall purpose of this coexistence agreement. And now I wish to draw members' attention to the preamble. This would be on page 5 of the record. Again, I will be referring to paragraph 5 of the preamble.
Page
5 of the record, Madam Presiding Arbitrator. Are members with me on this page? I can read out the clause which I'm referring to. Here, I'll be referring to the clause which reads, and I quote, "Whereas to facilitate the use and registration of their respective trademarks worldwide, the parties desire to enter into this coexistence agreement." Now, members of the tribunal, we submit that the background and context of this coexistence agreement is one of that possesses a collaborative nature. Now, such a term ought to be implied into this coexistence agreement to give effect to the intentions of the parties to begin with. Now, on top of that, members of the tribunal, we also note that there is a distinction between license agreements and registration, with the licensing agreements being governed by clauses 1.1 to 1.3, whilst the registration being governed by clause 2.1. Now, we submit that there is the distinction here between registration and license agreement simply because registration connotes a greater degree of permanence. Now, given that parties have applied their minds to this particular distinction and expressed it within the coexistence agreement itself, unnecessarily, parties should nonetheless be open to this view of having the opposing side's trademark be registered within the same jurisdictions. Furthermore, members of the tribunal, in clause 2.1, in particular the last line of clause 2.1, it states where registration is permitted under the coexistence agreement. My apologies, members of the tribunal. Please give me a few moments to refer you to another document. Now, members of the tribunal, as a final point, I wish to refer you to page 29 of the record. This would be under procedural order number 2. I will be focusing on point number 23. Now, the question here is, what are the jurisdictions where registration is permitted under the agreement? And here it references clause 2.1 and states that it relates to countries where either party has a registered trademark and the other party wishes to register its mark. Now, clearly, from this, members of the tribunal, it is well within the intents of the parties to have a situation where one party possesses a registration and the other party attempts to make a registration of their own trademarks. Therefore, it will only be consistent with 2.1 to have such a positive obligation on the respondents to assist my client with their trademark applications. Now, members of the tribunal, may I just do a quick check as to whether there are any concerns of this submission before I move on to my next one? Then I shall move on to the second part of my submissions pertaining to the license agreements. And for this case, my client's position is that the respondent has breached the coexistence agreement by refusing to enter into the license agreement per my client's request. And the reason why we say that is because they have not accorded to their obligations under clause 1.3 and 1.2. And this would be on page 5 of the coexistence agreement as well. Now, members of the tribunal, in clause 1.2, it stipulates that the respondent would be under an obligation to enter into license agreements only subject to two different circumstances. Number 1, where their rights are infringed, and number 2, where entering into such license agreements would cause confusion with their trademarks. And we submit that it is important to read this clause together with 1.3, as it also governs the rights and obligations of parties regarding the license agreements. Now, in clause 1.3, it states, and if applying to the respondent here, that they ought to enter the license agreements in good faith and shall not withhold such consent for unreasonable reasons. Now, the whole crux of my client's case here is that the respondent has refused the license agreement proposal by my client for unreasonable reasons, on the basis that we submit that there are no detriments to the commercial interests that could arise because of them entering into the license agreements. Now, we submit this on the basis that both parties are trading in very distinct industries. And as for the confusion point, members of the tribunal, this is a point that is already well within the minds of the parties, given that it is precisely because of confusion that they entered into this coexistence agreement to begin with. Therefore, the crucial aspect of this matter is the determination of whether or not one's commercial interests would be affected, for which we submit the respondent's commercial interests will not be affected by entering into this license agreement with my client.
You pass on.
Yes.
Just you have said that there was confusion, right? And that confusion was the issue upon which you did not want to enter into the licensing agreement, correct?
Madam,
The confusion was the reason in which the respondent had alleged that the confusion was the reason for which they did not want to enter into the.
Yes, correct, Madam Presiding
Have you had conducted any evidence with regard to consumer surveys indicating that there could be any confusion? Has there been confusion? Because you all have been coexisting for some time. Has there ever been consumer confusion on this between the hardware and the software registration of their trademarks?
Madam Presiding Arbitrator, there has not been any surveys that has been conducted thus far with respect to the Asian jurisdictions which my client seeks to trade in currently. Now, as for other jurisdictions which parties may have faced such conflicts in, this is not instructed by my client to me, Madam Presiding Arbitrator. However, I think the overarching point here that we ought to make is that aside from the confusion that could potentially exist, now the confusion point is not of crucial importance given that they are trading within distinct and separate industries. What matters at hand is whether or not the respondent's commercial interests would be compromised by entering into this license agreement with my client. Now, furthermore, members of the tribunal, the respondent has not commenced trading whatsoever in those Asian countries. Now, if that were to be the case, members of the tribunal, we submit that there can be no confusion that exists at all, let alone a compromise of their commercial interests. Therefore, if this were to set a precedent for the respondent's conduct as with regard to the coexistence agreement, then it would seem that the respondent can very well monopolize any industry insofar as they are the first ones to step foot into it and obtain a registration of their trademarks. Members of the tribunal, it is on this basis which we submit that the respondent cannot contend that because of confusion, therefore, they refuse entrance into the license agreement with my client, because that would simply defeat the purpose of this coexistence agreement to begin with, which is precisely for parties to coexist within the same jurisdictions.
I have a question.
So are you saying, therefore, that the decision taken by the respondent not to be part of the licensing agreement is not in good faith, and it has been exercised capriciously and arbitrarily? Is that what you're saying?
Yes, Madam Presiding Arbitrator, and this would be in contravention of Clause 1.3 in particular, because they have withheld consent for unreasonable reasons.
May I ask you this question?
Yes, certainly, Mr. Arbitrator.
You have successfully prevented through orders of court the respondent from seeking registration and using their products in the jurisdiction where you have registered your mark. Is that correct? Yes. Now, you would have done so on the basis, on what basis have you done so? You would have done so, I presume, on the basis that it would cause confusion with your mark in your market.
Mr. Arbitrator, we submit that the focus here is not on the matter of confusion, because I think as my learned friends would agree with me as well, it is precisely because of this potential confusion, given the similarity of the trademarks, that parties even enter into these license agreements to begin with. Now, I was not instructed by my client as to the specifics as to why such court orders were obtained. However, our position is that should it follow the flow, my apologies, Mr. Arbitrator, please go ahead.
Sorry. Let me just, on that point that you just told us, so if the whole idea was that there was an underlying agreement or an underlying admission by both parties at the time of entering into this coexistence agreement that some amount of confusion would arise from the names being similar and the fonts being similar.
That is correct.
Then if that was the case, then why would you specifically leave causing confusion with its existing marks as a grounds to refuse a licensing agreement in your contract?
Mr. Arbitrator, that is exactly the reason why we submit that clause 1.2 in this case would have to be read in accordance to 1.3, because 1.3 is the clause that sort of encompasses both 1.1 and 1.2 itself, which governs the rights and obligations with each party, depending on which party is the one that is granting said license agreements. Now, therefore, the crux of this matter is to go to the commercial interests, and I know I have belabored on this point, members of the tribunal, but simply there is no detriment to the commercial interests of the respondents in this case, and my client should very well...
To summarize, what you're saying is that the idea of causing confusion with its existing marks, those words in clause 1.1 and 1.2, needs to be read in the context of any commercial disadvantage that would arise to the other party. Is that what you're saying? That is the interpretation you're spinning on this?
That is exactly right, Mr. Arbitrator. Members of the tribunal, I note that my time is up, unless I may be of further assistance.
I go back to what now.
Yes, Mr. Arbitrator.
With regard to your first point about an implied condition, are you going to, or you didn't expand on any legal precedent, or do you have any judgments to support your contention that, or on what basis should a condition be implied in such a situation? Do you have any authorities, legal authorities or judgments on that point?
Certainly, Mr. Arbitrator. To begin, which is the starting point being the existence of a true gap. For this, it stems from the landmark and seminal UK Court of Appeal case of the Murcock in 1889. It states that any implication of terms should accord with the commercial purpose of the coexistence agreement. And as I have explained earlier, commercial purpose here must be one of a that encourages the collaborative nature between the parties in order to give effect to the purpose of this coexistence agreement to begin with. Now, as for the implied duty on the respondent to provide said positive assistance, we are relying on the 2017 UK Court of Appeal case of Moot and Merck. Now, this case here also set out the parties' rights and obligations when dealing with each other's trademarks, and it is very relevant here, given that it also concerns a coexistence agreement. Now, here parties were bound by their duties, and in particular, the court held that both parties were under an obligation to support the purpose of the contract and to desist from all activities which might endanger its achievement. Therefore, Mr. Arbitrator, we submit that a positive obligation on the respondent to assist will only give effect to the entire purpose of this coexistence agreement.
So on both counts, you are going on the basis that the purpose of entering into a contract was purely on a commercial coexistence, and anything that messes around with that coexistence would amount to, or that there is an implied term that you can't destabilize the coexistence. Is that the point?
That is generally our position, Mr. Arbitrator, and it is precisely because previously parties were in a very unstable position prior to the coexistence agreement. So necessarily when they enter into this coexistence agreement, what they would be expecting, a situation of peaceful coexistence, which is what the claimant, my client, is trying to push for here.
Thank you.
I have no further submissions. Thank you very much, members of the tribunal.
I have a question.
Oh, sorry. Yes.
Right. In the interpretation of your agreement, you ask us to rely on the aspects and the purpose of why this agreement was entered into, and that was to ensure, coexistence. How about if you were to twist that argument the other way and say that the fact that if that were the purpose, would it not have also been a natural consequence to include a clause that spoke of each party assisting the other in the event that registration was required? In the absence of that clause, My point is that would the absence of that clause negate the presumption or the implied condition that you are trying to bring into the contract? How would you respond to that?
Understood on the question, Mr. Arbitrator. Well, you contend here that the absence of such an express provision does not negate the possibility of an implied obligation on the respondent to provide said assistance to my client, simply because implying this term will only give effect to the purpose of the entire coexistence agreement. Now, I know that my time is up, but if I may introduce a case law to support this proposition.
Yes, go ahead.
Much obliged. Members of the tribunal, for this you'll be relying on the 2022 UK Court of Appeal case of RE Force India Formula One team. Now, what happened in this case was that the court also went ahead to imply a term into the agreement stating that the court here implied a term to delineate the sale profits between the two parties. Now, I ought to provide some context for clarity, and in this case, what happened was that the Formula One team Force India had recently been acquired by another corporate entity. Now, in this case, the corporate entity would engage in the sale of merchandise in order to raise profits for their own company. As such, in the contract that was subsisting within that case, it did set out the terms of the sales of the merchandise, such as who the property rights of the merchandise belong to, but there was no express clause stating how the sales profits and revenue ought to be divided across the parties. And necessarily, that is also a point that flows very naturally from a sales of merchandise, members of the tribunal, similarly to a situation which we are faced here. Therefore, we submit that it does not in any way negate the possibility for this tribunal to imply such a term into the coexistence agreement.
Thank you. Noted.
Unless I am able of any more further assistance, I have no further submissions. Thank you very much.
Just to refer to you too, there are 3 cases which I thought you all would be referring to because that really dealt with a lot of these things. Braganza versus BP Shipping, Regina versus Johnston, which talks really about coexistence, which can exacerbate because of confusion and the liability of infringement. Then Mears Limited versus Cost Plan Services Southeast, which is a 2018 case. Mears Limited versus Cost Plan Services. The Apple Call versus the Apple Computers, which talks about the intention, which must reflect the intention of the parties. And the Compass Group UK and Ireland Limited versus Mid-Essex Hospital Services NH Trust, which is also a 2013 case. Thank you.
Thank you very much.
Can we please have the next speaker?
Good afternoon, members of the tribunal and my learned opposing counsels. As introduced by my co-counsel, my name is Anika Sehgal and I will be presenting our arguments on merit. While the claimant has already presented their perspective on the situation, it is crucial for this tribunal to consider the full context of the situation before arriving at any conclusion. Accordingly, in my submissions, I'll be attempting to mirror the arguments presented by my learned opposing counsel and be seeking to establish that we have not breached the coexistence agreement as 1, no positive obligation arises out of the coexistence agreement, and 2, that we have denied the license agreement on reasonable terms and have hence not breached the license agreement. To substantiate the first prong of my argument, we submit that no positive obligation to help the other party in getting their trademark registered arises out of the coexistence agreement. If I may take the tribunal towards Claimant Exhibit 1, page 5 of the record, which is the coexistence agreement. Clause 2 of the said coexistence agreement is the provision regarding registration of trademarks. The said clause is titled Non-Interference and it reads, both parties agree not to challenge or oppose each other's registrations of their respective marks in the jurisdictions where registration is permitted under the agreement. We submit that the terms of this particular clause are clear and unambiguous in the obligations that they create and the scope that they entail. Further, merely the fact that the word facilitate has been mentioned in the preambulatory clause of the contract is not sufficient to give rise to an obligation to provide a letter of consent. This was held in the case of Attorney General versus Riverdori, where it was held that if the term of the contract itself is clear, then the recitals cannot be extended to the contract, and in any case, the recitals cannot create an obligation, a new obligation on their own. Further, to substantiate, to counter the point presented by my learned opposing counsel that the intention of the parties was in fact to include such a positive obligation within the contract, I want to draw the attention of the tribunal towards, firstly, towards page number 2 of the report. The said page is the statement of facts, the request of arbitration submitted by the claimants themselves. If I may draw your attention towards point number 6 of the statement of facts, and if I may read for the convenience of the tribunal, it reads that the claimant has effectively barred the respondent from using or registering the kryptonite mark in Rosnia, while the respondent has reciprocated by thwarting claimant's effort in Galvia and other Asian countries. Similarly, if I may draw your attention towards page number 16 of the report, point number 4 and 5 of the statement of facts reads that claimant has attempted to prevent respondent from using or registering its mark citing claimant's registration in Rosnia. And to address this contentious situation, which is arising out of the active opposition being filed by the other party to prevent the registration, is why the parties have entered into this coexistence agreement, acknowledging the similarity of their marks. And this agreement was crafted to ensure that each party could continue to operate across each other's territories without undue interference. Hence, this clearly shows that the purpose of the contract was not facilitation of trademark. Rather, it was to ensure that both parties are able to get their trademark registered without an active opposition by the other party. Further, to clarify the point that was presented by my learned opposing counsel regarding this defeating the purpose of the contract, I want to draw a clear distinction between the problem that was being faced by the claimants earlier versus the problem that they are facing now. The problem that the claimants were facing earlier in getting their trademark registered was the fact that because the respondents are holders of a similar trademark, we had the right to oppose the registration of their trademark. However, what has happened in the present case is that we have not opposed their registration. The IP authorities themselves were of the opinion that use of these two trademarks simultaneously would cause confusion, and that is the precise reason why they have been denied the registration in this particular case. We submit that facilitation of a trademark and non-interference are two different obligations, and only the latter is covered under the purview of the current coexistence agreement. We further submit that the obligation of good faith, as highlighted by my learned opposing counsel, mentioned in clause 1.3 of the coexistence agreement. This obligation merely requires the respondents to uphold the obligations that arise out of this particular contract in good faith and to do everything that we can to not violate the provisions of the contract. And this is not sufficient to impose a completely new obligation that was not included in the contract, expressly excluded by the members, despite having the knowledge that there is the provision of doing this. Hence, we submit that the very fact that we have not opposed their trademark registration is sufficient to discharge our obligations under the non-interference clause of the contract. Moving on to my second major argument, we submit that we have not acted in breach of the clause 1, which is regarding licensing agreement. To further the same, we have a two-pronged submission. Firstly, we submit that the obligation to enter into the license agreement itself was not an absolute obligation. And second, that we have denied the license agreement based on a reasonable. If I may draw your attention towards clause 1.2 of the coexistence agreement. Clause 1.2 of the said agreement lays down that LexCorp agrees to allow Wayne Enterprises to use its trademark for communication software in the Asian countries where LexCorp holds registrations under a license agreement on agreed terms, provided that such use does not infringe upon LexCorp's rights or causes confusion with its existing marks. We submit that this obligation to enter into a license agreement is contingent upon the fact that both parties are able to arrive at certain agreed upon terms under which they want to enter into the said license agreement. In the present case, it is mentioned that both parties have engaged in, if I may take you to question number 41 of the procedural order 2, it's on page 31 of the record. Question number 41 here provides that there have been discussions between both the parties regarding potential license. However, no agreement. Yes, so the parties have engaged in negotiations and discussions. However, they could not arrive at any agreed upon terms under which they would enter into the licensing. We submit that the very fact that the parties have engaged in negotiations is alone sufficient to fulfill our obligations under the clause 2 of the clause 1 of the coexistence agreement. We further submit that we have denied the license agreement based on a reasonable reason. If I may bring you back towards clause 1.2, page number 5 of the record, clause 1.2 clearly consists of a proviso which provides that the parties have to enter into this license agreement only when such use does not infringe upon LexCorp's rights or causes confusion with its existing marks. We submit that in the present case, we have denied the license agreement based on the reason of public confusion, which is a reason which is considered to be a reasonable reason as it is provided in the contract itself. We submit that in the present case, there is a significant possibility of public confusion. Section 10 of the UK Consolidated Trademarks Act of 1994 lays down 3 requirements for the same. The first is that the 2 logos have to be similar. The second is that the products have to be similar. And the third is that a reasonable consumer should not be able to distinguish between the 2 companies. We submit it in the present case. The first fact, that is similarity of trademarks, is something that has been accepted by both the parties to the extent that both agree that the trademarks are not only similar but almost identical to each other. We further submit that secondly, both the companies are engaged in trade of similar products. This is a fact which has also been accepted by my learned opposing counsel. And we also want to substantiate on it by stating that the claimant is a communication software company, whereas the respondent is a hardware company. Both of them belong to the broader computers category and the same class, that is the class 9 of the niche classification. We submit that based on this, we can reasonably conclude that both products are similar to each other as they are complementary. Thirdly, we submit that a reasonable consumer will not be able to distinguish between these 2 products. The standard of reasonable consumer was laid down in the case of, yes, Mr. Arbitrator.
No, you complete your submission. You're supporting it with the case authority.
Sure, Mr. Arbitrator. We submit that the standard of a reasonable consumer was laid down in the case of Apple Corps versus Apple Computers, and also in multiple other cases like the Canon case, the case of Puma versus BB Sable, etc. In all these cases, it was held that the principle of global appreciation combined with the principle of imperfect recollection is applied to determine whether there will be confusion or not.
I wanted to ask you, on your argument, how do you contest the position of the claimant that the words in the agreement allow you to resist the license agreement on the basis that it causes confusion with its existing mark, and the tense of the words used is that it must cause confusion now in a situation, but the situation is that you're not in that market now, and so how can your products be confused with theirs because it speaks of a present tense?
Yes, Mr. Arbitrator. The clause provides that we can deny the license agreement if it causes confusion with our existing mark. We submit that we have already registered our trademark in the said Asian countries. Further, the definition of the word use is a very broad definition. And if we look at page number 16 of the record.
That is my point actually, because page 16, para 6 speaks of you proposing to commence trading activities. So you're speaking of a possible confusion in the future.
Mr. Arbitrator, firstly, to reiterate, existing mark is a broad phrase and it must also include the fact that we have already registered our trademark. Further, existing mark, even if existing mark is to require use of that trademark in that particular country, use does not necessarily have to include having a commercial presence. If I may draw your attention towards paragraph number 2 of the same page as pointed by you, it provides that the respondent's product bearing this mark represents innovation and excellence in the realm of computer hardware, and the respondent has invested significant resources into building this brand, making it synonymous with quality and reliability in the region. This covers the entire Asian region, which will include the present Asian countries in question. Further, even investing resources regarding a particular establishing a particular company in a particular area is considered to be used as per the canon case. Hence, we submit that we have an existing mark falling within the purview of the terms of the contract in the said Asian countries, and in any case we are to further expand in these countries by establishing full commercial presence in these countries. Based on these two
That
major
you-
arguments, we
Sorry,
Yes.
just a question.
Yes.
You had earlier registered this trademark. Thereafter, did you stop using that trademark? Was there any time at which you stopped using the trademark? Did you stop using the trademark? Because what they wanted was a letter from you to the registration for purpose of registration saying that you're not using that trademark to avoid confusion. Is that not what happened?
No, Madam Arbitrator, we responded by saying that we do not yet have a commercial, we are not yet trading in that particular country, but we are in the process of commencing trading in those particular countries, which will lead to public confusion. And the fact about use of trademark that you pointed out, we got this trademark registered only in the year 2022, and as of the date of the dispute, it had only been, it was only the year 2023, and hence, and even in that time period, we have been investing resources and establishing our presence and consolidating our name in the entire region, and hence we cannot arrive at the conclusion that we have stopped using our trademark ever since it got registered for the first time, and hence based on this we submit that we have not we were justified in denying them license agreement on grounds of potential public confusion. Considering the paucity of time, I will just sum up all. Yes, Mr. Arbitrator.
Sorry, just to understand your response to my question, your position is that even though you are not using the trademark at present in that market, it will still cause confusion in view of the reputation your brand has in all those countries, regardless of whether you're using it or not. Is that correct? Right.
No, Mr. Arbitrator.
You're relying on question 31, is it, that speaks of, does the respondent have a reputation in the business of using the name kryptonite? The answer, yes.
Mr. Arbitrator, can I get an extension of 1 minute to answer that question in
Yes.
sum up?
Yes, of course, you may.
Thank you.
With your permission.
Mr. Arbitrator, we beg to differ from the position that you just referred to. What we are saying is not that we are not using our trademark in the said country. We are saying that the definition of the term use of a trademark itself is a very broad definition as given in the canon. It is not only considered to be using a trademark when we have a full-fledged commercial presence and trading in that particular country, but even investing your resources in that country and building your reputation are also considered to be used. Considering this fact, combined with the fact that we have just combined with the fact that we are planning to commence full trading in that country, we submit that it will cause public confusion, and hence we are justified in denying the license agreement.
Correct. So what I said was that even though you are not actually trading at this time, you say that there is a current violation of the causing of confusion or current causing of confusion by the very fact that you have already developed a reputation in that market as being the owner of that mark. Is that correct?
Yes, Mr. Arbitrator, that combined with the fact that we are investing significant resources.
Can we go back to your first point about the implied condition? You agree that the parties entered into this agreement to coexist in the different markets, right? That is the whole point of a coexistence agreement, correct?
Mr. Arbitrator, till now we have been existing in different countries, and this is the first instance.
No. I'm saying is the whole purpose of the coexistence agreement was respecting each other's specific rights to coexist in the markets, right? So if you look at page 8 of the brief, paragraph 3, they are only asking you to facilitate, correct?
Yes, Mr.
Right, and they specifically say your cooperation would not only be greatly appreciated, but also aligns with the spirit of cooperation and mutual benefit outlined in the coexistence agreement. Right? Now, is it reasonable that when they only ask for facilitation, they are not asking for a positive act from the respondent, only to facilitate? Is it reasonable on your part, on the respondent's part, to completely refuse to facilitate?
In fact, before you answer that, just a corollary to that question also, which might be answered together. If you were to raise the issue of causing confusion as being something that would arise because of the reputation you've already built, then would there be any purpose at all to the coexistence agreement? Would it fulfill, any commercial sense?
Yes, Mr. Arbitrator. To answer that one by one, to answer the first question as raised by you, we submit that facilitation in the sense what they are asking for is that they are demanding for a positive action to be done by the respondents in submitting a letter to the IP authorities of the said countries. And the same is not covered within the purview of the coexistence agreement as already substantial.
Yes, that's my point. Hold on. That's my point. Isn't that unreasonable? Because they are just the respondent is sticking to a strict interpretation of the words in the contract, the literal terms and conditions of the contract, without looking at the purpose of the contract, right? Okay. So is that reasonable? That's what I'm asking.
Mr. Arbitrator, we submit that we are not merely reading the words of the current coexistence agreement, but even if we look at the intention of the parties entered into the said coexistence agreement only to avoid the problems that were arising out of active opposition by the proprietor of the earlier trademark while attempting to get their own trademark registered, and it in no way included, and the parties were aware of the fact that that the process of facilitation of providing a letter is something which happens while which is one of the provisions in getting the trademark registered. However, despite this, they have chosen not to include this obligation within the terms of the coexistence agreement and expressly exclude it, which is sufficient to show that the parties did not even intend to include any such obligation, and therefore even through an expansive interpretation we cannot assume that this obligation falls within the purview of the coexistence agreement.
Can you take that argument on that position when clause 1.1 and 1.2 also referred to each party specifically allowing the other to use its trademark? Can you take the argument that this coexistence agreement was only designed to prevent interference in the registration process when there is a very clear undertaking by each party to allow the other to use? And doesn't it, by that condition, don't you presuppose that whether there is going to be confusion or not, the use will be permitted? And so can you cite that now as a reason for not going ahead with the licensing agreement?
Mr. Arbitrator, firstly, we submit that the obligation under clause 1 and clause 2 are different. Clause 2 is the clause that deals with the registration, and clause 1 deals with the obligation regarding entering into a license agreement. Secondly, combining this with the previous question that you asked regarding whether we can deny on grounds of public confusion and whether the contract itself would then make any sense or not, we submit that the parties have chosen to expressly include an exclusion in favor of situations when there is a public confusion. Further, the contract will still hold good because the clause 1.1 as well as 1.2 have a proviso which say that parties have to enter into a license agreement on agreed terms provided that there is no confusion. Therefore, the parties have the full right to arrive at any set of agreed terms that they deem fit, which will allow them to coexist as well as to avoid public confusion. To cite an example of an actual coexistence agreement, in the case of Worldwide Fund versus World Wrestling Federation, the two organizations had confusingly similar logos with the letters WWF in the same color and font. those parties entered into a coexistence agreement and by mutual agreement decided that one of them will change their font and color a little bit to avoid confusion. Similarly, even in the present case, there is no hindrance to the parties agreeing on any terms which they deem fit to ensure that they can also coexist and not cause public confusion at the same time. But in the present case, the parties have not been able to arrive at any such term, and hence we can deny registration on grounds of confusion.
Thank you.
Thank you.
If the tribunal has no further questions, this will conclude my submission.
Our time has
Thanks a
elapsed.
lot. Thanks.
Thank you.
Members of the tribunal, I apologize, but I do not have visibility on this tribunal. May I begin my rebuttal?
Yes.
Thank you very much, members. Members of the tribunal, I share the sentiments here that the purpose of this agreement is for parties to coexist. Now, on that note, I think we ought to take a step back in this matter. The fact remains that the respondent has yet to commence any form of trading whatsoever in those jurisdictions for which my client seeks to obtain the license agreements in. Insofar as they have registered their marks, this cannot alone be the basis for which they reject our license agreements proposals. If that were to be the case, members of the tribunal, then it sets a precedent for future instances where the respondent would be allowed to monopolize any industry they so wish, insofar as they obtain registrations within those industries, or perhaps, as my learned friends have put it, invested resources, but yet have not commenced any form of trading whatsoever. Now, therefore, members of the tribunal, the respondent has certainly been in breach of this coexistence agreement by refusing the license agreement as per my client's request. Unless I may be of further assistance to this tribunal.
Wasn't there in addition to question 31 on page 30, I recall also reading elsewhere that each of the parties have established a fairly wide reputation in their respective areas. So in the Asian area for the respondent and in the Americas in the American continent for you, of their ownership and the reputation of their marks. So the argument put forward by the respondent was that that reputation alone entitles them to rely on the question of confusion, because even though people may not be trading in that market, people are aware of their brand in the market, and that your presence might cause confusion. Would that not negate your argument that the mere fact that they haven't started trading is sufficient to demonstrate that there will be no confusion?
We understand your concern, Mr. Arbitrator, and respectfully we take a differing position on this. Now, with regard to the two aspects of confusion and reputation, these two have not changed throughout the entire process of these parties' relationships. Confusion undoubtedly exists because of the similarity of the trademarks, and their reputation is well established. And that is undisputed, Mr. Arbitrator. However, we have to dive into the commercial interest, because if we focus on just the matter of reputation resulting in confusion, then we submit that clause 1.3 has lost its purpose, and subsequently there is no means of coexistence pursuant to this coexistence agreement.
Yes, but then we come back to that question of why would you retain those exclusions in your contract specifically? Why would you say subject provided that it does not cause confusion, provided that it does not hinder your trade or each other's trading in that market? Why would you do that if this area of confusion was given at that time? And
and to add to it, it's the essence, actually, it's the essence of this, that there should be no confusion. I mean, that's, and they had invested money, they had said, it was ongoing, and then when you come in that they say that, well, they are renowned for that, would it not cause a reasonable confusion?
Perhaps I can first address Mr. Arbitrator's question. Now, that is precisely the reason why my client submits that confusion here should be read in the context of 1.3, because it encompasses the rights and obligations of parties when it comes to entering into the license agreement. And to answer Madam presiding arbitrator's question here, confusion does indeed remain in whatever context, and the reputation of parties is undisputed that it is well established as well. However, the fact of the matter is that in order for this coexistence agreement to even take any effect, then necessarily it cannot be the case that insofar as there is reputation on the part of either party, then the other party will be precluded from trading within those jurisdictions, be it under a registration or a license agreement. In those scenarios, members of the tribunal, it would seem that parties would essentially be plunged back to square one, as if the coexistence agreement had not even been entered into in the first place. Therefore, we submit that such a restricted reading of the coexistence agreement cannot hold water, and therefore the respondent should be under this obligation to accede the license agreements as per my client's request.
We are possessed of your
Thank you.
argument.
We are possessed of your.
Much obliged, members of the tribunal.
Madam Arbitrator, we have the respondent's rebuttal remaining.
As per my rebuttal, I seek to establish a two-pronged rebuttal. Firstly, that both the parties are prudent parties who were well aware of the IP processes in both the countries, and they have long-standing reputations in their individual areas, and hence were aware of the fact that there is a reasonable possibility of public confusion, but still chose to include this exclusion in the contract itself. And second, that this will not bring us back to square one as the situation was before the coexistence agreement came into being, as the obligation of non-interference is clearly provided, which was not there before, and is followed by both the parties. And second, that the parties are free to arrive at any negotiated terms that they deem suitable to coexist alongside avoiding public confusion. If the tribunal has no further concerns, then I rest my submission.
So clear, succinct, some clause which should exclude confusion. That is really your main argument, isn't it? That it is a confusion that is caused in the market, correct?
Yes, Madam Arbitrator. Thank you so much. It has been a pleasure arguing before this trial.
Dear counsels, that bring us to the end of the submissions. Please bear with us as the arbitrators deliberate. Thank you. Thank you to the participants for an exciting final round of competitions. Before winding up the proceedings for the day, I would like to request all the participants to turn their cameras on and join us for a screenshot. In 3, 2, 1. Yes. Counsels, we hope you enjoyed your time at Victor's Moot 2024, and thank you once again for being a part of this year's edition. We wish you all the very best in your legal careers. Do join with us for the closing ceremony in the evening, and the judges will give their feedback at the closing ceremony. Have a pleasant rest of your day.
Thank